all of the work involved in assessment, whether it's a qualifying exam or whether it's a fitness for duty evaluation, involves a balance of interests. Now, these interests include the examinee's property rights and their civil rights. It also includes, and in particular, those rights related to being free from discrimination, whether it's adverse treatment or adverse impact. Of course, adverse treatment being those activities that serve to actively discriminate from, on the basis of some protected class. And disparate impact are those that are facially neutral but have a discriminatory effect, although the treatment itself is not discriminatory. It just has a discriminating impact on them. So freedom from discrimination is an examinee's property and civil right. Due process rights. We're talking a fair amount about due process rights, about privacy, and in particular about procedural rights. This is where you kind of wish that you were Canadian, because the procedural rights underlying ADA are far more significant, as you'll see this morning, and this afternoon, than the anti-discrimination qualities of the Americans with Disabilities Act. The procedural requirements are far more daunting, and they're much more likely to trip you up than those that relate to discrimination itself. There are also, in addition to the employee's rights and interests, or the examinee's rights and interests, there are the employer's legitimate business interests that also need to be balanced. And that includes freedom from civil liability, their duties and responsibilities with respect to protecting community safety and organizational and operational efficiency. Their interest in being free from substantial disruptions in the workplace, from employees that are disruptive to the operations and activities of an agency. Their freedom from undue hardship as the accommodating interest, whether they be protection from, as a result of a disability or as a result of a religious conviction or practice, or privacy interests, they have a right to be free from undue hardship, as it's defined under the law. And then there are the public's interests. In particular, they are interested in being free from mistreatment by peace officers who, under the color of authority, may cause injury. They have a right to expect that a peace officer is competent to perform their duties psychologically. And then, of course, there are the examiner's interests. And we, too, have an interest in freedom from civil liability. And that includes being able to practice in a way which complies with practice standards, and being able to practice in a way that complies with the statutory requirements. So we want to be able to perform our duties in a way that allows us to comply with those requirements, where an organization doesn't compel us because of their ignorance or because of their perhaps even intentional demands, put us in a position where we're practicing outside the standards of practice. We also have an interest in being able to practice in a way which is ethical, particularly with respect to multiple relationships, informed consent and disclosure, competent practice, and protection of confidentiality. All of the things that we're going to be talking about today and tomorrow are designed to aid you in balancing these interests. The examinees, the agencies, the publics, and your own.